Good afternoon, ladies and gentlemen. It is just clicked over 12 o'clock. And we've got a lot of firms joining us this afternoon. So the only people where it's still morning is Perth, maybe South Australia with this change of time as well. So I'm not quite sure how all that works, but welcome to the next in our Lunch and Learn workshop series. As there are quite a few joining, I'll give everyone another 30 seconds or so to jump online before I do any sort of formal introductions. But there's quite a few flowing through, which is great to see. Grab yourself a cup of tea if you need one. I've got one. And sit back and enjoy the next probably 35 to 40 minutes as we take you through the next in our Lunch and Learn series, which is around, we're going to talk about family law today. So, but again, I know there's a number of you coming on board and I'm just checking our attendees. Yep, there's a few rolling in, which is great. All righty. Look, I will kick off. I know there'll be probably quite a few that would join us over the next 35 minutes or so, but welcome, ladies and gentlemen. Welcome to our Lunch and Learn workshop series. It's great to have you all back. It is our next in our line for 2023. Now, we've got firms from everywhere joining us, so thank you for joining us today, as well as if you're part of a teams. I know a number of firms now sort of put this on in their boardroom, they get their teams, they get some lunch in. So if you're team members that are joining us as well and you haven't seen this before, thank you very much. We're here thanks to our partners at Professional Partners Education and Hall Chadwick, Profitmaster Global, iKeep and Lloyds Auctioneers. For those of you that don't know my name's Paul Jansz and I'll be your host today. A big shout out to Danielle Morrison. I'm not quite sure if Danny's online yet. I know she sent me a message before saying, have you got the link? So hopefully she's online. You've all been invited because you're friends of Professional Partners Education or friends of Hall Chadwick. So certainly we're privileged to be able to provide this series to you. If you missed anything in 2023 and certainly last year as well, everything is on our YouTube channel. So if you go to just call up a normal page on your browser, YouTube, type in Professional Partners Education, everything we've done, certainly from these Lunch and Learn, more, let's say on the technical side, as well as all my other educational workshops that I do and my live shows, it's all there. So it's free. It's all built for you guys as a part of our community to give back to you guys. Now, our topic today is family law, and always an interesting one. I know I was a guest at a workshop probably about 12 months ago now, and there was a law firm that also spoke about family law, and I was actually intrigued and was quite amazed with the amount of information that I learned that day. So I'm looking forward to sharing that with you guys. We've got our special guest here. We've got our good friends from Rostron Caryle Rojas joining us today. I've got Tuskeen Jacobs, one of their partners and a family accredited specialist. Tuskeen, how are you?
I'm very well. Thank you, Paul. Thank you for having me.
It is our absolute pleasure. Thank you for being a part of these little learning workshop series. Now, before we kick off, let me share a little bit about what we're going to talk about today. So we're going to talk about prenups. We're going to talk about commercial mediation benefits and role. We're going to talk about loans from parents to children and how that could look with regards to a separation. And then we're going to go into, let's say, how we determine the asset pool of parties at separation, the role of a binding financial agreement, consent orders, these sorts of things. So strap yourself in. We're probably going to be here for about 35, 40 minutes. It's all recorded as well. So if you've got team members or partners that have missed out, it's all recorded and it will be on our YouTube channel pretty shortly after today. Now, Tuskeen, I'm going to start with you, if that's okay. Before we get into any questions, are you okay to share a little bit about you and your experience at the law firm you're at, which is our good friends at Rostron Caryle Rojas?
Absolutely. So I have been an accredited specialist for over 20 years now, solely in family law. Rostron Caryle Rojas, we do tend to focus more on the corporate side of property settlements, so your complex untangling assets. We also do focus a lot on complex parenting matters, but family law covers everything from dividing up the house and contents to divorce to child support, domestic violence. We got a team primarily based here in Brisbane, but also a small team in Sydney and Melbourne.
Brilliant, brilliant. Which obviously you can provide advice to all firms wherever they may be, which is a fantastic.
Absolutely. Family law is federal, so every state is covered by us.
Very, very true. Okay, let's start with prenups. So tell us, is there anything new or how prenups may work in this new world in 2023?
So prenups are still relatively new to Australia. We copied America like we do with a lot of things. And in 2001, the government decided to introduce them. I'll explain the basis, if you like. It's both parties must get independent legal advice. There's full disclosure as to the assets that everyone has, and then it's drawn up by one lawyer, and both parties and their lawyers will sign it. They're generally used for parties that have either gone through the system before, so don't want to go through the family court system again and want to protect their assets. Your typical prenup is what's yours is yours, Paul, what's mine is mine, and in the event of separation, how do we divide our joint assets? And most people agree that the easiest way is an equal split. So if we buy a house or apartment together, we separate, divide net proceeds equally. Although what I have seen more recently is, particularly where there's a real imbalance of wealth, I might say to you, well, hey, let's buy an investment property. It's worth $1 million. We need 100,000 deposit. You've only got 10 grand in the bank. I've got the remaining 90 grand to deposit. So we might hold that property with me holding 90% interest and you 10, so that in the event of separation, we then divide it based on our contribution to that asset. And I see a lot of couples or spouses coming through going, well, that seems fairer, rather than an equal division where you might have contributed very little, if anything, to the property, and you therefore benefit, if you like. So that's probably more your common type of prenup that we're seeing now.
Okay, brilliant, brilliant. And look, to all of you online, thanks. There's more firms that have just joined us, which is awesome. If you've got any questions along the way, please drop them into the Q&A bar. And we've definitely got time for questions, because I know there could be a few that come up, so which is great. Although we know we're going to cover quite a lot today as well, which is awesome. Let's go into family law. Family law, family law commercial mediation benefits. It's probably often looked at as sometimes probably the less costly option. Keeps you out of the courts. It can salvage business reputation, continuity, overall success of the business being maintained. Tell me a little bit about that.
Okay, so prior to September 2021, the mediation wasn't that popular. What happened in September 21 is that the government decided to overhaul the family law system in Australia. So we had all new rules come into effect. And mediation is now compulsory for both parenting and property matters in Australia. If you don't attempt to mediate, or in fact mediate before commencing an application to court, the court may very well go, no, put a stop to your application. There may be cost consequences that flow if you try and invoke the court's jurisdiction. So yes, mediation is compulsory. In my experience, I'd say probably 3/4 of matters do settle at mediation for the exact reason you said. Court is costly. It's emotionally draining. I say to everyone, no one wins when you go to court other than the lawyers and barristers. So you have your whole life on display before a judge who doesn't know you, doesn't know your kids, doesn't know what drives you, and makes an arbitrary decision as to how to divide those assets. Whereas in a mediation, you have more control. You can explore different types of settlements, the length to pay someone, as opposed to a judge saying you've got 30 days to pay your ex-husband or wife. But also, the other thing you mentioned, which is just the cost of mediation. A one-day trial in the Federal Second Family Court will set you back anywhere from 50 to 100,000. A mediation, anywhere from 10 to 15,000, depending again on the complexity and the asset structure, etc. So many clients can see the benefit of, let's go straight off to mediation. Let's not even talk about court until we've exhausted all our options at a mediation.
Is there a time frame when that should commence, or is it up to either party that they feel that, okay, the time is right now, or does it have to happen immediately, or?
No, there is a time frame in that it must occur within 14 days of you inviting the other person. Sorry, no, let me rephrase. The invitation to mediate must occur within 14 days. So usually it takes several weeks to engage a mediator and to obviously prepare. There needs to be full disclosure of assets. If we're talking about businesses and properties, we'll need to get those valued, and that might take several weeks as well for that to occur. So typically mediation can be organised within about 6 to 8 weeks of everyone agreeing on the mediator and, the venue and all of those sorts of intricacies.
Okay. And is there, does it need to go down, let's say, engaging with a law firm like yourselves, or are they, for example, I know in Victoria here, there is the Victorian government provides for example, Relationships Victoria. Is that something that's available in?
Yeah, that is right around the country. There are private mediators, so no, you don't need to engage lawyers to assist you. Again, with parenting, a lot of times I'll say to clients, you don't necessarily need me there holding your hand. Most of the times, it's best for your children. So yeah, it's on a without prejudice basis. So anything that you might say won't be used against you if you don't settle your matter at a mediation and subsequently end up in court. So a lot of clients do take that opportunity to try and resolve it themselves, save on legal fees, and then they come back to the lawyers to draft whatever agreement they've reached, whether with respect to property or parenting.
Yep. Okay, brilliant. Again, to everyone, if you've got questions, let me just quickly check. There's no questions in there, but if you do have anything to do with any of these, I know it's triggering my little questions, having been through it. So it is interesting still to find that information. And I didn't realize, 2021 mediation.
So prior to 2021, it wasn't compulsory to mediate about property matters at all. It has been compulsory for parenting matters for, oh gosh, a good 10 years, but property, it absolutely was not. So if you separated and had tried your very best to reach an agreement with your spouse or partner about how to resolve your property issues, and you couldn't, and you came and saw me, I would say, okay, let's try. And if you said, no, Tuskeen, I've tried, I'd say, okay, well, if you don't wish me to try that with, their spouse, let's file an application, and that could be filed within a week to court. Now the court is saying absolutely not. Mediate, try and resolve it, and only then do you come to us. And even then, once you're in the court system, the judicial officers still have a discretion to order you to do another mediation if they feel there's any benefit.
Interesting. It's an interesting process, isn't it?
It is. It's. I think the intention is to really move people towards a conciliatory process rather than that combative process that we see in court.
And that's probably the one we see. That's the one we probably see more of, combative.
Yes.
So,
yeah.
That's no good for anybody. Well, maybe
no. Again, it's good for the lawyers, yes, but not good for particularly in parenting matters where your kids are going to have weddings and you've got to try as best you can to navigate that for a very long time. So there is a move to really encourage people to try and work together, particularly where it's related to parenting issues.
Very true. No matter how hard it is, it's very true. Let's talk about loans. Let's talk about loans from parents to children upon separation. What does that look like? So
that is a very, very common issue that arises in family law. So it's not uncommon for, the bank of mum and dad to gift you 50,000, 5,000. I had a client recently who had a gift from the parents of nearly $500,000 that she'd kind of forgotten about when she was disclosing her assets to me, until her dad, who came in, went, do you remember that money I gave you? So what happens is, again, depending on the dollar value, money is exchanged. It's called a loan, but it's never intended to be repaid back. And suddenly separation arises, and then mum and dad will say, hey, we actually want that money back. Or the party that received the benefit might go, oh, we actually have to pay my mum and dad back. And the other party says, no, we don't. That was a gift they gave us 5, 10, sometimes even, 20 years ago. So it does arise quite frequently. What the court, and therefore what we as lawyers do, is to say, is it a legitimate loan that is required to be paid back? And if the answer to that is no, then it's not taken into account as a liability of the marriage. And in this example, let's say I received the benefit of a $50,000 gift from mum and dad. That's then looked at when we look at my contributions in terms of towards the asset pool. So I might get a benefit, which we'll talk about later. I might get a benefit in property settlement for that reason. If the answer is that it is a legitimate loan, the court is going to be asking itself, is there a loan agreement? Okay. So that might evidence that it is intended to be repaid back. We're looking at things like interest, etc. More importantly, we're also then looking at the history of repayments. So if there's a loan agreement, but it's been in existence for, again, long period of time, no money is repaid back, court may form the view that it's not a legitimate loan, it's a gift. Other things we look at is, if it is a legitimate loan, have the parents taken steps to enforce the loan? So it's not uncommon to say to the mum and dad bank, will you sue your son or daughter if they don't repay this money back? And if the answer is yes, then it's a legitimate loan. It's then deducted as all other liabilities when we're looking at the assets to be divided between the parties. So best advice I can give to clients is, if you are loaning monies to your children, documented and treat it like a loan. If there's interest, calculate the interest on a regular basis. Call upon that child to repay the loan, so that if there is a separation, there's no ambiguity. It's clear for everyone that it's a legitimate loan required to be paid.
Interesting. So yeah, because you can see that happen quite often, I suppose, where parents look, I'll lend you $10,000 to buy your first car. So saying always have an agreement in place, so it's more of a loan rather than a gift.
Yeah. If you don't, and we'll talk about it when we talk about how we divide assets, if you don't have all those indicators in place, then just be mindful. If you are, the elderly parents that gifted, loaned 10, 50, 100,000, you may not get it back, and also, your child may get the benefit of that money, but it's not going to be a dollar for dollar benefit. So yeah, best advice is documented if possible, but if not, you're not going to get your money back unless you try and sue your child in your local court.
Interesting. So my brain goes into whether it's a loan. What about if it was an inheritance? Different?
Look, if it's an inheritance, then the same thing applies. Okay. If I get, again, I'm just sticking with 50,000 because it's a nice, easy number. If I inherit 50,000, I bring that into the relationship over and above what you've brought into the relationship. So in the event of separation, when we're looking at, hey, what did Tuskeen contribute versus what Paul contributed, I'm going to get a greater percentage division, if you like, of the assets because I contributed more. So it is taken into account. It's not that we forget about it, but it's easier if we're arguing the case of a loan that needs to be repaid back. It's absolutely easy. If there's some evidence and some history of repayments, then there's no ambiguity and parents are getting their money back. But in saying that, obviously, as typically happens, monies that mum and dad gave me, they argue it's a loan. The intention is I pay that money back. As soon as I give it to mum and dad, they just give it back to me in any event. That's just a win for me, and you lose in this scenario.
Yeah, look, I suppose there's, even in any sort of a loan, you might loan friends. I've loaned friends money along the way, and for whatever reason, they decide not to pay it back for whatever reason. But you're right, very rarely would we, and I'm just looking at myself, I've never put a loan agreement in place. So it's something that we don't tend to do, is it?
No, that's right. Again, I think it comes down to the amount of money. Where there's a significant amount of money with, commercially savvy parents, they generally do tend to get a loan agreement. And, I've seen matters where there's correspondence, weekly or monthly emails from dad to son saying, this is the interest rate for the month, here's your calculations. Then there's no ambiguity. And it's very hard if you're acting for the spouse at saying, hey, we don't have to give your parents $100,000 back because they've never called on this loan. It's very easy to go, no, here's the monthly emails, absolutely, and there's a loan agreement. And more importantly, if we don't repay them, they're going to commence proceedings against us and be joined to our proceedings in the family court, or pending proceedings in the family court. Yes. So in those instances, absolutely. But where we're talking lesser amounts, like $5,000-10,000, most people don't go off to lawyers and get a loan agreement prepared up. It's your son or your daughter. You trust them. They say they're going to repay you. You go, yeah. If it's 5 years and they haven't repaid you, again, it's family. You think they're going to do the right thing by you.
Yep, that's a good point. It's a good point. Let's go into the pool of assets, because it's an interesting one. So let's talk about asset pool of parties at separation and the role of a BFA consent orders.
Okay, so I'll start by explaining how we as family lawyers divide assets, and it's effectively it's 5 steps, but I'll narrow it down to 3. What we're looking at as lawyers or judges, if you're before the court, is to go, what is the balance sheet? So we want all the current assets minus all the current liabilities. And we don't care if you have set your structures up so that you have companies, trusts. If you control it, if you are the majority shareholder, if you're the trustee, then it forms part of your matrimonial asset pool. Okay, so that's step number 1, going, what is the balance sheet to divide up? Then we're looking at step number 2, to the contribution. So when parties start living together, that's the key date of the marriage date. So the cohabitation date, what did they each come to the relationship with? Okay, and then we look over the course of the relationship at their contributions to those assets. So before, when I said, hey, if there's no loan agreement and I got given $50,000 or I got inheritance of $50,000 and you didn't, if we're then before the court and I'm saying, hey, I came to the relationship with $100,000 and Paul came to the relationship with nothing, the court might give me an adjustment in terms of contribution. So I might get a 10% adjustment compared to you. So now I'm at 60%, you're at 40%. And those percentages range depending on the contribution and the length of the relationship, amongst other things. Once we've done that and determined contributions, we then look to what we call future needs. So those are things like if there is a disparity in income earning, if there are children of the marriage and one party is having more care of the children, if there's health issues, whoever's worse off by virtue of earning less, having more care of the children because kids cost money, or being older and therefore having less time in the workforce, that person will get an adjustment of the property in their favour. So it's a bit of, I guess, social engineering that the law does to try and even the score, if you like. So that concept that it's a 50-50 is very rare. 50-50 is if came to the relationship, same amount, contributed same amount, and we're leaving the relationship and we have similar age, similar income, equal time with the kids, or the kids are over 18. But more than not, there is an adjustment made along the way because your spouse might earn less. So she or he might get, 5% more of the property than you to compensate them for that. Okay, so that's law 101 in terms of how we divide up the assets. As I said, we're looking at the current value of all assets, and I think the key to take away for all the accountants that may be online or financial planners, because this commonly arises where people say, if you put it in a trust, don't worry about it, it'll be safe. Absolutely not. The Family Law Act says even if you controlled that trust at one point in time and you saw separation looming and went, let me further protect my assets by, removing myself as the trustee. No, the court can go, let's undo all that hard work you've done. Let's reinstate you back to the trustee so that we get all those assets that you've tried to remove from your name back into this matrimonial pool and then divide it up with your ex-spouse. So there's a number of cases where, commercially savvy, sophisticated clients have done that to try and protect or quarantine some assets for themselves. And family court has simply gone, no, we're bringing it all back in and we're now going to divide it. Okay. Once we've determined the division of assets, what we then want to do is to document that division in one of two ways. The preferred way is a consent order. So a lot of times clients go off to banks and banks will say, no, you want a binding financial agreement, which I'll talk about in a minute. We don't like that as lawyers. We like consent orders. As the name implies, it's an order made with your consent and my consent. Both clients sign it. You don't even need independent legal advice. You don't, thanks to COVID, don't even need your signature witness these days. So just scribble your name and we file it online, pay the court currently $190, and within a matter of weeks, you've got a consent order made. Okay. So that is the preferred. It's cost effective. It's relatively easy. Okay. If we're doing something a little bit tricky that we think the court may not approve of, it's not illegal, it's just a little bit tricky in that the Family Law Act says we have to document an agreement that as best we can unravels your financial ties as if you were never married. So what commonly arises is, let's say we've got an investment property, but the market's bad and we don't want to sell that property. We want to hold on to it for, I don't know, say 2 years. So we want to divide it all up, but have some assets that are still in joint names for a period of time. If we lodge that with the court, we haven't severed our financial ties and the court may not approve that order. Okay, so we can still document the agreement into a binding financial agreement, but as a rule of thumb, at least double the cost. Both parties must get independent legal advice, and that's where people go, oh, but he or she doesn't want to go to lawyers. They don't want to pay the cost of the lawyer. You might have to pay their fees if that's the case. Yes. Okay. We also generally don't like it because our insurers don't like binding financial agreement. Our insurers like us to do consent orders because the responsibility rests with the court rather than with us as the lawyers.
Yes. Okay, brilliant. I was actually, my brain was thinking about a few things there, and now I should have written them down because then I could have asked you the question. Now, look, I'm going to open it up to everyone online as I keep thinking of sort of one of the questions in there as well. Oh, yes, I've just got it back. So if you've got any questions you want to throw into the Q&A, let me check. There's nothing there at the moment. So you will have your question answered straight away as I go to one before we look to wrap up. What are we? 30 minutes in, so perfect. How does the consent orders then fit with, let's say we've got kids, let's say I don't know, what do they call it? You probably know, the family plan, or is it the children's
parenting plan?
Parenting plan, that's the word. Yep. I've got one, I just couldn't get out.
So parenting plans are good. And I'll choose my words carefully because we're told as lawyers to, wherever possible, recommend them. Parenting plans are not filed with the family court, or it's now called Federal Circuit and Family Court. So they're not filed with the court and therefore they're not enforceable and binding. So they work really well, in my personal view, in two situations. One, where there's a high level of trust between separated parties. Okay, so you can tell by my face that in my experience, that's a minority of the population.
Yes.
Because if we agree that, for example, the kids are coming back to dad on Sunday at 5 o'clock for the week, but I decide, I don't know, I want to go on a holiday with the kids, so I don't take them back, there's no recourse for you as the parent that's had the plan breached to go, hey, I'm going to go to court, I'm going to ask the court to punish you, to fine you and impose other sanctions. So it does require parents to really honour the agreement that they've reached. And that's not always the case. So often we see parents doing parenting plans, but the plan is not working because people just keep breaching or tinkering with it and the goalposts keep shifting. So then they'll come back to us and say, well, I want something binding. I want consequences if, this plan is going to be breached, in which case we say you need a consent order, because the consent order is like the parenting plan. It's signed by the two parents, but it's filed with the family court. And therefore, then there are consequences if one or either of the parties breach it. The other type, I think, parenting plans are good are where you first separate and it's still unclear as to what's going to be in the kid's best interests, or you've got young kids that you don't know the agreement that you reach now when they're 2 is going to best suit them when they're 5, because 0 to 5 they change so dramatically. So again, it requires a high level of trust, but it can move with the children as opposed to a consent order, which is this is the agreement and it's in place until the kids are 18. Okay.
Right. So you can't change those consent orders?
You can, but you require the other party's agreement to change it.
Yes.
And sometimes you can't get that.
Very true.
Okay, so
both consenting.
Yeah, exactly. So again, if you're separating and you're resolving your property issues and you do have children, my advice to any client would be you might have the best co-parenting relationship. It's an amicable separation. You agree that little Jimmy is going to live with you 5 nights a fortnight and mum the remaining, or whatever the arrangement is. If we're documenting your property settlement and filing that into a consent order, let's put some clauses on to that order so it covers both for property and parenting, and you're not coming back to a lawyer in months or years where the parenting agreement's gone out the window and we're fighting every second week about where the kids go. So if you can reach an agreement about everything, you should, in an ideal world, and we can document that all into consent order, and hopefully, you each go your merry way.
Yeah. Okay. Good to know. I always like picking up little bits and pieces that could affect your own life. So it is quite interesting. But I suppose to all the firms that are online, whether you've gone through it yourself or you're going through it, I know people that are going through it as well, or you've got clients that are going through it. This is the great thing about this, hopefully bring this situation into what you can tell them, what you can advise them, how you can go to Tuskeen and maybe get some further questions answered. So let me just quickly check some questions. Oh, there's none. Okay, that's a good thing. So please, if you've got any questions and you want to ask, please drop it into the chat bar now. We'll be looking to wrap up in a couple of minutes' time and stick to our time frame. So that's fantastic. There was one that I just wanted to highlight that we couldn't get to, and it's probably because again, it was time. So one of the topics on our agenda was to talk about the valuation of businesses. And while we spoke about this about half an hour before we went live, and Tuskeen went into, there's probably going to be about 4 or 5 different ways to do that. So we thought we might leave that for another session, given the fact that we usually run these for about 35-40 minutes. So Tuskeen, have you got anything you'd like to share with regard to that without going into any detail though?
Sure. So valuations of businesses, again, very common because the business owner will say that business has nil to, some negligible value, and typically the, non-business owner, which I'll say is the wife, and I'm stereotyping, I apologise, but for a reason, will say, no, that this business is worth a mozza because, it's allowed us to live this wonderful lifestyle. So what we do is then go, okay, we're lawyers, we can't value it. You guys can't agree. The family law rules say if there's a dispute on any asset, whether it's a house, car, business, we engage a joint valuer. So that's starting point, trying to agree on which valuer. There's, in each state, a good amount of reputable valuers that do family law valuations. The process is joint correspondence is sent to the valuer, and he or she starts by collating the income tax returns, financial statements and business records for the last 3 financial years. And we do that because whilst one party will say the business is doing, for example, poorly because they know that, hey, last financial year was bad. We want to get a really good snapshot of what this business has been doing and can be doing. So the valuer has sent all the financials. They may ask questions. It's all done again on a joint basis. So there's no bias. No one can accuse the valuer of, valuing it less, for example, for one party, or valuing it higher than the other. And then depending on the structure of the business, you can have a business where they're looking at what we call the future maintainable earnings of the business. You can have one where they're looking at if it's heavily asset-based business, what those assets are. If it's, I'm just sorry, Paul, I'm mindful about how much.
No, that's okay. That's okay. That's okay.
Time, because we did discuss this.
Agree. Look, to everyone online, we were going to have this, and when we, as you can probably tell, we sort of decided to leave it off the agenda, but bring it back into one of our future lunch and learn. So we'll definitely get you back to go into the detail of that, because I think it's definitely worth it. There are some questions coming through. So g'day Ricardo, how are you, mate? Good to have you online again. Is there such a thing as a post-nuptial agreement? So clients who are having issues want to take the financial aspect away from their relationship by agreeing now as to how assets would be split in the event of a divorce somewhere down the track.
Yeah, absolutely. So, as I said, your typical one is a prenuptial, but yeah, absolutely. If there's pending separation, and again, or even if we're uncertain, then yes, a post-nuptial agreement can absolutely be done. It's the same process. Lawyers are engaged. Needs to be full disclosure of assets and liabilities by both parties. Both parties must go off and get independent legal advice prior to signing the agreement. And then it sets out, in the event of a separation, how we divide those assets. And look, to be perfectly frank, on the occasions that I've drafted post-nuptial agreements, I don't know whether that's been the glue that has kept couples together, because I then haven't, and I've been doing this for over 20 years now, haven't had someone come back to me and say, yeah, we actually did in fact separate, and we're now implementing the terms of that agreement. So it could be that it saved the relationship, or it could be that the agreement was drafted so well that they didn't need to come back to the lawyers, because that's the intention, to draft the agreement that covers every scenario in terms of separation and how we divide those assets. So you don't need to go back to the lawyers. So you've drafted it to say, you keep X, I keep Y, we divide joint assets in this manner.
Yeah, interesting. Very interesting. No, I hadn't heard about that one either. So that's great. Great question, Ricardo. Any other questions? Oh, there's another one just popped up there. Hey, Nick, how are you, bud? If a business has been trading well and has provided lifestyle for 20 years, but COVID has detrimentally affected the business with a severe downturn, how much weighting will the historical trading have on a val?
That's a very good question. And it really did, as I said, we start by looking at the last 3 financial years. So, I mean, COVID has been 2020. A lot of the valuers are saying to us that all the economists are saying we're coming out of that, COVID slump, if you like. So if you're looking at this year and the business has done well, but we've had 2 years of bad trade, it's now doing well again, it's probably more likely that the valuer will say that this business has this potential, as opposed to if you valued it, in the midst of the COVID slump that we had. Yeah.
Okay. Good one though. Great question. So team, just a quick one to everyone online, and to you, Tuskeen, if people have got more questions, want to find out, where can they find you?
You can find us at, sorry?
Or how can they find you?
They can find us at Rostron Caryle Rojas. As I said, main office is here in Brisbane. I'm primarily based in Brisbane, but we do service other states as well. Family law is federal, so every state law is the same. Yeah. There's
just a greater amount of sunshine in Brisbane than there certainly is in Melbourne at the moment. We've hit winter, definitely.
Yeah, no. As you might see over my shoulder, we've got, I think, a balmy 25 or 28 degrees in Brisbane at the moment, so it's fantastic.
Great. That's what we want to hear. Hang on, there's another sneaky question that came through. Danielle's going to send an email to everybody, and that'll include all the Tuskeen's DJs as well. So Danielle will follow up, and I know Tuskeen's on LinkedIn as well. So if you wanted to reach out, there's a name down there. You can write that down or reach out right now and send her a note and say thank you. So to all of you that are online, thank you for joining us. That wraps up. It's 12:42. So Tuskeen, thank you. I know that we've spoken a few times, and we will come back and talk about the business valuations in more detail in one of our further lunch and learns, because these are monthly on the second Tuesday of every month. Hopefully there's not too many. There was a few people that turned out a bit late. So maybe the old chocolate Easter egg hangover came into play today. So first day back to the office. Although I know it's school holidays as well, so I know a lot of people are away. So I certainly appreciate everyone joining us today. Now, keep an eye out. My next Empire Masterclass show is on April 20. I'm pretty sure I've got that date right. 12 p.m, where we're talking about data breaches, data hacks, everything to do with data security. We know we've been through, whether it be Optus, whether it be Medibank, whether it be Canva. They were probably the first one that got hit a few years ago, and more recently, Latitude Financial. So we know there's a lot of interesting things going on. I reckon I hit up on this with some sort of scam nearly every day. So, and it's easy not to get sucked into, because they're telling you things that the way you write. So that's called email business compromise. So we're going to go into a little bit about that as well. It's going to be a great topic, a lot of learning. 20 April, look out for the invite. If you haven't already seen it, jump online and register. We've got a lot of firms already registered. So jump online with team members and work out how we can share a little bit more information with you, how you can protect your data, and also share that with your clients of how they can do that as well. So hope you can join us then. I think we're done. Thank you, Tuskeen. Thank you. To everyone else, enjoy the rest of your day, wherever you may be. And until I see you next time, we'll see you then. Thanks very much.